Welcome to the appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source, Trustees of Dartmouth College vs. Woodward, 4 Wheaton, 518, 1819. Heir to the Supreme Court of New Hampshire, Dartmouth College had been established in 1769 by a charter granted by King George III. In 1816, the State of New Hampshire altered this charter and organized under the new charter a new Board of Trustees. The old Board of Trustees refused to accept this change and argued that the Act of New Hampshire was unconstitutional because an impairment of contract contrary to the federal constitution. The opinion of the court that a corporation charter was a contract was of considerable importance in the subsequent business history of the country. Its significance, however, was limited by the decision of the court in the Charles River Bridge versus Warren Bridge case. Marshall, Chief Justice. This court can be insensible neither to the magnitude nor delicacy of this question. The validity of a legislative act is to be examined, and the opinion of the highest law tribunal of a state is to be revised, an opinion which carries with it intrinsic evidence of the diligence, of the ability, and the integrity with which it was formed. It can require no argument to prove that the circumstances of this case constitute a contract. An application is made to the Crown for a charter to incorporate a religious and literary institution. In the application, it is stated that large contributions have been made for the object, which will be conferred on the corporation as soon as it shall be created. The charter is granted, and on its faith the property is conveyed. Surely in this transaction every ingredient of a complete and legitimate contract is to be found. The points for consideration are: 1. Is this contract protected by the Constitution of the United States? 2. Is it impaired by the acts under which the defendant holds? 1. On the first point, it has been argued that the word contract in its broadest sense would comprehend the political relations between the government and its citizens, would extend to offices held within a state for state purposes, and to many of those laws concerning civil institutions which must change with circumstances and be modified by ordinary legislation, which deeply concern the public and which, to preserve good government, the public must control. That even marriage is a contract, and its obligations are affected by the laws respecting divorces. That the clause in the Constitution, if construed in its greatest latitude, would prohibit these laws. Taken in its broad, unlimited sense, the clause would be an unprofitable and vexatious interference with the internal concerns of a state, would unnecessarily and unwisely embarrass its legislation, and render immutable those civil institutions which are established for purposes of internal government, and which, to subserve those purposes, ought to vary with varying circumstances. That as the framers of the Constitution could never have intended to insert in that instrument a provision so unnecessary and so mischievous and so repugnant to its general spirit, the term contract must be understood in a more limited sense, that it must be understood as intended to guard against the power of at least doubtful utility, the abuse of which had been extensively felt, and to restrain the legislature in future from violating the right to property. That anterior to the formation of the Constitution, a course of legislation had prevailed in many, if not in all, of the states, which weakened the confidence of man in man, and embarrassed all transaction between individuals by dispensing with a faithful performance of engagements. To correct this mischief, by restraining the power which produced it, the state legislatures were forbidden to pass any law impairing the obligation of contracts, that is, of contracts respecting property, under which some individual could claim a right to something beneficial to himself, and that, since the clause in the Constitution must in construction receive some limitation, it may be confined, and ought to be confined, to cases of this description, to cases within the mischief it was intended to remedy. The general correctness of these observations cannot be controverted. That the framers of the Constitution did not intend to restrain the states in the regulation of their civil institutions adopted for internal government, and that the instrument they have given us is not to be so constructed, may be admitted. The provisions of the Constitution never had been understood to embrace other contracts than those which respectively property or some object of value, and confer rights which may be asserted in a court of justice. It has never been understood to restrict the general right of the legislature to legislate on the subject of divorces. The party in this case differed less on general principles, less on the true construction of the Constitution in the abstract, than on the application of those principles to this case, and on the true construction of the Charter of 1769. This is the point on which the cause essentially depends. If the act of the incorporation be a grant of political power, if it create a civil institution to be employed in the administration of the government, or if the funds of the college be public property, or if the State of New Hampshire, as a government, be alone interested in transactions, the subject is one in which the legislature of the state may act according to its own judgment, unrestrained by any limitations of its power imposed by the Constitution of the United States. But if this be a private, eleemosynary institution, endowed with the capacity to take property for objects unconnected with government, whose funds are bestowed by individuals on the faith of the charter, if the donors have stipulated for the future disposition and management of those funds in the manner prescribed by themselves, there may be more difficulty in the case, although neither the persons who have made these stipulations nor those whose benefit they were made should be parties to the cause. Those who are no longer interested in the property may yet retain such an interest in the preservation of their own arrangements as to have a right to insist that those arrangements shall be held sacred. Or if they have themselves disappeared, it becomes a subject of serious and anxious inquiry whether those whom they have legally empowered to represent them forever may not assert all the rights which they possess while in being, whether if they be without personal representatives who may feel injured by a violation of the compact, the trustees be not so completely their representatives in the eyes of the law as to stand in their place, not only as respects the government of the college, but also as respects the maintenance of the college charter. It becomes then the duty of the court most seriously to examine this charter and to ascertain its true character. Whence then can be delivered the idea that Dartmouth College has become a public institution and its trustees public officers? Not from the source from whence its funds were drawn, for its foundation is purely private, eleemosynary. Not from the application of those funds, for money may be given for education, and the persons receiving it do not, by being employed in the education of youth, become members of the civil government. Is it from the act of incorporation? Let this subject be considered. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its creation confer upon it, either expressly or as incidental to its very existence. These are such as are supposed best calculated to affect the object for which it was created. Among the most important are immortality, and, if the expression may be allowed, individuality, properties by which a perpetual succession of many persons are considered as the same and may act as a single individual. They enable a corporation to manage its own affairs, and to hold property without the perplexing intricacies, the hazards, and endless necessity of perpetual conveyances for the purpose of transmitting it from hand to hand. It is chiefly for the purpose of clothing bodies of men in succession with these qualities and capacities that corporations were invented and are in use. By these means, a perpetual succession of individuals are capable of acting for the promotion of the particular object, like one immortal being. From the review of the Charter, it appears that Dartmouth College is an eleemosynary institution incorporated for the purpose of perpetuating the application of the bounty of the donors to the specified objects of that bounty, that its trustees or governors were originally named by the founder and invested with the power of perpetuating themselves, that they are not public officers, nor is it a civil institution participating in the administration of government, but a charity school or seminary of education incorporated for the preservation of its property and the perpetual application of that property to the objects of its creation. According to the theory of the British Constitution, their Parliament is omnipotent. To annul corporate rights might give a shock to public opinion, which that government has chosen to avoid. But its power is not questioned. Had Parliament, immediately after the emanation of this charter and the execution of those conveyances which followed it, annulled the instrument so that the living donors would have witnessed the disappointment of their hopes, the profundity of the transaction would have been universally acknowledged. Yet then, as now, the donors would have had no interest in the property. Then as now, those who might be students would have had no rights to be violated. Then as now, it might be said that the trustees, in whom the rights of all were combined, possessed no private, individual, beneficial interests in the property confined to their protection. Yet the contract would, at that time, would have been deemed sacred by all. What has since occurred to strip it of its inviolability? Circumstances have not changed it. In reason, in justice, and in law, it is now what it was in 1769. This is plainly a contract to which the donors, the trustees, and the Crown, to whose rights and obligation New Hampshire succeeds, were the original parties. It is a contract made on a valuable consideration. It is a contract for the security and disposition of property. It is a contract on the faith of which real and personal estates have been conveyed to the corporation. It is then a contract within the letter of the Constitution and within its spirits also, unless the facts that the property is invested by the donors and trustees for the promotion of religion and education, for the benefit of persons who are perpetually changing, though the objects remain the same, shall create a particular exception, taking this case out of their prohibition contained in the Constitution. It is more than possible that the preservation of rights of this description was not particularly in view of the framers of the Constitution when the clause under consideration was introduced into the instrument. It is probable that interferences of more frequent recurrence, to which the temptation was stronger and of which the mischief was more extensive, constituted the great motive for imposing this restriction on the state legislatures. But although a particular and a rare case may not in itself be of sufficient magnitude to induce a rule, yet it must be governed by the rule when established, unless some plain and strong reason for excluding it can be given. It is not enough to say that this particular case was not in the mind of the convention when the article was framed, nor of the American people when it was adopted. It is necessary to go farther, and to say that, had this particular case been suggested, the language should have been so varied as to exclude it, or it would have been made a special exception. The case, being within the words of the rule, must be within its operation likewise, unless there be something in the literal construction so obviously absurd, or mischievous, or repugnant to the general spirit of the instrument, as to justify those who expound the Constitution in making it an exception. On what safe and intelligible ground can this exception stand? There is no expression in the Constitution, no sentiment delivered by its contemporaneous expanders, which would justify us in making it. Almost all eleemosynary corporations, those which are created for the promotion of religion or charity or of education, are of the same character. The law of this case is the law of all. The opinion of the court, after mature deliberation, is that this is a contract, the obligation of which cannot be impaired without violating the Constitution of the United States. The opinion appears to us to be equally supported by reason and by the former decisions of this court. 2. We next proceed to the inquiry whether its obligations have been impaired by those acts of the legislature of New Hampshire to which the special verdict refers. The obligations, then, which are created by the charter to Dartmouth College were the same in the new that they had been in the old government. The power of the government was also the same. A repeal of this charter at any time prior to the adoption of the present Constitution of the United States would have been an extraordinary and unprecedented act of power, by one which could have been contested only by the restrictions upon the legislature to be found in the Constitution of the state. But the Constitution of the United States has imposed this additional limitation, that the legislature of the state shall pass no act impairing the obligations of contracts. It has been already stated that the act to amend the charter and enlarge and improve the corporation of Dartmouth College increases the number of trustees to 21, gives the appointment of additional members to the executive of the state, and creates a board of overseers to consist of 25 persons, of whom 21 are also appointed by the executive of New Hampshire, who have power to inspect and control the most important acts of the trustees. On the effect of this law, two opinions cannot be entertained. Between acting directly and acting through the agency of trustees and overseers, no essential difference is perceived. The whole power of governing the college is transformed from trustees appointed according to the will of the founder expressed in the charter to the executive of New Hampshire. The management and application of the funds of this eleemosynary institution, which are placed by the donors in the hands of trustees named in the charter, are empowered to perpetuate themselves, are placed by this act under the control of the government of the state. The will of the state is substituted for the will of the donors in every essential operation of the college. This is not an immaterial change. This system is totally changed. The charter of 1769 exists no longer. It is reorganized, and reorganized in such a manner as to convert a literary institution molded according to the will of its founders and placed under the control of private literary men into a machine entirely subservient to the will of government. This may be for the advantage of this college in particular, and may be for the advantage of literature in general, but it is not according to the will of the donors, and is subversive of that contract on the faith of which their property was given. It results from this opinion that the acts of the legislature of New Hampshire, which are stated in the special verdict found in this case, are repugnant to the Constitution of the United States, and that the judgment on this special verdict ought to have been for the plaintiffs. The judgment of the state court must, therefore, be reversed. Mr. Justice Washington and Mr. Justice Story rendered separate concurrent opinions. Mr. Justice Duvall dissented. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.